take instruction. Well, also I recollect that matter. The petitioner has been, but university has taken action against her, and she was not allowed to appear in the examination. And in the writ petition, he has prayed for a special arrangement for sitting in the examination. But may I submit that there are 2 days in our hand for preparing the question paper, and it is not possible because the midterm, unless the petitioner appears in the midterm examination, she cannot appear in the final examination. And the final examination is scheduled to 22nd, 22nd of May. Prior to that, she has to sit in the midterm examination. The result will be published. Then she can sit in the final
So
examination.
midterm examination, they could not appear.
They can appear.
They could not appear.
Could not appear, and she prayed the rulership for a special arrangement to.
No, that is special arrangement we may not grant, but just consider that aspect where you have suspended them. That is the only aspect. Examination, yes, midterm examination, you could not appear.
No. My learned senior probably is taking instruction. What the university can do, they can arrange after, because 22nd it's actually not possible on the part of the university to allow me to sit for the exam because I'm not appeared for the midterm exam. So after the exams are held by now, in fact, my client, she had spoken to the university authority. They said that yes, that we will allow you to appear for the exam. Just wait for 2 months time. We asked that at least give it to us in writing so that I can be assured.
No. We will keep the matter pending.
Yes, sir.
We will keep the matter pending. In the meanwhile, we will see what are they.
I assure that after the examination will over, the 3 students will be provided special classes.
That is great.
Yes.
Very good gesture on part of the university.
Yes, ma'am.
And you can you observe this? So that
We will not observe now. All right. Because the very fair stand has been taken. We will just wait. We cannot forget the facts of the case. Can never. So we will remember it.
I only think
Okay.
that punishment has to go better.
Punishment, let them. Will you file an affidavit or what?
I will file affidavit in that. And the victim girl is the first year student she has not been made party. What is the clear case of ragging? She knows. But it is
I'm very sorry.
Just a minute.
Now they're trying to improve. They're trying to supplement something which is not there at all. If it is a case of ragging, we would have proceeded under the UGC guidelines or not.
As requested on behalf of the university, list this matter on first week of June, opening week, on 21st. On 21st, within first 5 cases, so as to enable him to seek further instructions, and file affidavit if so required. He may not be required to file any affidavit. If in the meanwhile,
Never in between let them
decision.
in between let them communicate.
I ensure after the examination,
Let them communicate to us that this is what we will do. Because I'm in shock right now.
We understand.
Mr. Rao?
Yes.
So, what happened to criminal misfiction? Criminal misfiction?
Yesterday it was listed, my lord, it got listed in its own. So, Honorable High Court has disposed of the reputation on the lines of Lalita Kumari Krishnan, asking the authorities to look into it.
So what was that about?
But the complainant is also lodged in FIR against us. I went to the police station to lodge a counter FIR, but that was refused. Rather, my allegations were far more serious in nature. But thereafter, I sent the complaint to the Commissioner of Police. That then also no action was taken. Pursuant to which I had filed a CRMP for the enacted on the part of the authority to get the FIR.
See, bring all those girls to the court. We will intervene. They should shake hands.
But in fact, the institution which is.
Criminal cases, their career should not start with criminal cases against each other. The vice chancellor or the authorities must intervene. Why criminal cases?
Yes, but I am compelled to do it because tomorrow, today they are asking you to give an undertaking in writing that I have, I'm guilty or not.
There is no question of guilty. You can see, if they ask you to give an undertaking, you can say that such thing will not recur in future. You can say that.
In fact, the presentation have said.
After all, they are your teachers.
Yes, sir. So I'm going to fight an institution which has given so much in the last 4 years.
Yes. Please ask the vice chancellor and whosoever is heading the institution that he should intervene. Have children.
Item number 1.
Primary education matter. The primary education matter. Lord, on 15/5/2024, my lords were pleased to pass orders.
Yes.
This will have taken instruction from the government. A draft format was given, so they request some modification to that. For that, some more timing required, because they have to prepare it in accordance with the provisions made under RTI Act and the instruction issued by the central government.
We don't have any problem. So let them do.
I have talked with Kashmir Malad. Just give me some more time.
Some more time means
After that,
after vacation. All right, after
in the meantime, we'll prepare the format and we'll
prepare the format. In the meantime, you may come out with this thing, a decision that you have already taken a decision.
Yes, ma'am. That I will
You can say that you have already prepared a software or decided.
In the meantime,
So before the court passes any order, you can do it.
yes, ma'am.
As requested on behalf of the state by learned AGA for seeking further instructions and complying this court's order dated last, list this matter on 24th.
No.
Within first 5 cases.
Item number 3.
Item 3 will be complied with, and then we will extend it to the prisoner.
Complied with.
Much.
Item number 4.
No one appears on behalf
Item
of
four.
the list this matter on after vacation July minute. Right.
Item 5.
Please, your lordship. Second contempt, your lordship.
Whether it has been complied with.
No, not yet, my lord. Neither have they challenged it before the apex court. The order was passed in 7/3/2022.
Where is the order?
Order, my lord, will find at page 8. Operative portion is that. Page 13, last paragraph. 19. I was earlier informed, my lords, and your lordship directly disposed of the content petition saying comply within 3 months. That was on February 2023.
So who is on the other side?
Matter, so maybe Finance Corporation lordship may issue notice. Only I pray if lordship could. I will take out by registered post. I will take out by registered post, lordship. And a returnable date.
Item number 6.
My opinion,
DC knowledge.
my lord, I am for the appellant, my lord. This
Yes.
matter, my lord, this is my lord, appeal relating. Can lordship hear me, my lord?
Yes, please.
Yes.
They are
My
heading.
lord, my lord, it's really, my lord, a question of law involved here. My lord, lordship will take the MSMED Act, my lord. My colleagues will give it to your lordship, my lord. Kindly take the act, my lord.
MSME or arbitration? MSME arbitration.
Just a minute, Mr. Sarkar. You want submission, Mr. Sarkar?
Yes, my lord. Now, my lord, if your lordship will take, my lord, chapter 5 of this act, my lord, deals, my lord, with payments.
Capital 5.
Chapter 5.
Chapter
Section 15 onwards. Section 15 onwards, my lord, this is, my lord, regarding recovery, my lord, of payments due, my lord, to a company covered, my lord, by this statute.
Yes.
So, my lord, he can file a claim, my lord, before the council. The council, my lord, under the statute constituted, my lord, he can appear before the council. So, when he
Yes.
files a claim, my lord, section 17. Then, my lord, what is important, my lord, is section 18. This is very important.
Yes.
Reference to Micro and Small Enterprises Facilitation Council. This is a council, my lord, I'm talking of.
Yes.
Notwithstanding anything contained in any other law for the time being in force, any party to a dispute may, with regard to any amount due under section 17, make a reference to the Micro and Small Enterprises Facilitation Council.
Yes.
So, a reference was made, my lord, in this case. Now, my lord, what is important, my lord, is what is the obligation of the council, my lord, once a reference is made, my lord, is what for a lot you have to consider.
Yes.
That was subsection 2.
Yes.
On receipt of a reference under subsection 1, the council shall, now it's very important, it's mandatory provision. my lord.
Yes. Yes. Yes.
It can either itself conduct conciliation in the matter or seek the assistance of any institution or center providing alternate dispute resolution services by making a reference to such institution and center for conducting conciliation, and the section 681 of the Arbitration Act will apply.
Yes.
So, one of these obligation, my lord, is condition precedent, my lord, is they must, my lord, have a conciliation. Then, my lord, subsection 3, my lord, is the conciliation shown so is not successful, stands terminated. My lord, either, my lord, take the dispute to arbitration or refer it to arbitration. So, my lord, condition precedent, my lord, of an arbitration is, my lord, under subsection 2, a mandatory obligation not to carry out a conciliation process either by itself or, my lord, by through some other agency who carry out, my lord, conciliation.
Yes.
Now, if you lordship look at the Arbitration Act, my lord, the conciliation provisions, which is, my lord, no longer there, my lord, but this applies in our case, section 65 onwards.
Mr. Sarkar, what wrong has been done in this matter?
My lord, what happened, my lord, was this. A claim was filed. You were asked, my lord, to file a response. We filed a response. They filed a rejoinder on day 1, my lord. They say, we take up conciliation. That's over. Now, my lord, then, my lord, parties went away. On that date, my lord, was asked to file a spreadsheet, my lord, substantiating the claim. On the next day, my lord, nothing else happened. On the very next day, my lord, the notice was given for adjudication. Next day, my lord, the council recorded conciliation has not happened. Therefore, we start arbitration on the same pleadings, on the same documents. Not, my lord, permissible in law. There's two different processes altogether, my lord, which my lord, the council could not follow, with obviously, my lord, respect, utmost humility and respect. My lord. First, my lord, conciliation is an independent process, my lord, the same pleading, the same document. My lord, law, my lord, prohibits that. I can cite, my lord, Supreme Court judgments on this point, my lord. Once, my lord, conciliation is another process where, my lord, parties open their cards, they talk amongst themselves. It's not adjudication at all, my lord. People say they can't be relied upon, my lord, later on, because, my lord, people make admissions, they can discussion. Here, my lord, same pleading, same documents, my lord, matter went to arbitration. Lordship, one, I can show, my lord, the orders, my lord. There is no.
Where is the order terminating the conciliation proceeding?
Yes, my lord, kindly take, my lord, the order. If, my lord, kindly take, my lord, first, my lord, take the first order, my lord, that's 17 November, page, my lord, 224. But I have given a prepared list of dates, my lord, that's not required. Page, my lord, 224 is the first order. After, my lord, we got notice. Kindly see the first order, my lord, page 224.
From which document? Writ petition
My
or?
lord, it is, my lord, annexure, annex to the appeal, my lord, in the part of the paper book, my lord, it's annexure B3, I think. I'm not sure, my lord. Internal, I've got a page 224 of the paper book, my lord. Lordship, you have the paper book?
Appeal 2 to 4. 2 to 4 of the appeal number.
2 to 4, just a minute.
2 to 4, I'm sorry, my lord. I hope, my lord, my pages are tallying with your lordship. my lord.
Just a minute.
I think it's annexure 3, my lord.
Just a minute.
I'm sorry, my lord.
So this is initiation of conciliation proceeding.
That's the first order, my lord. It's the first order. Met on 17 November 2022 to adjudicate. Now, lordship will see, my lord, it's a long order. My lord, we had, my lord, filed our, my lord, reply before this because we were directed to file a reply. That is, my lord, lordship will see, my lord, is recorded. Then, my lord, summary of the case, my lord, is recorded. And then, my lord, lordship will see at, my lord, finding at page, my lord, 228. After recording, my lord, all these pleadings, under the above circumstances, the council initiates conciliation process under section 18(2) of the Act for amicable settlement of dispute among the erring parties. Council directed the petitioner to file detailed spreadsheet incorporating OP-wise bill so-and-so before the next sitting of the council. Remember, OP number 1 is directed to file counter rejoinder and so on. That was, my lord, the first order. Then, my lord, comes a notice, my lord. We received a notice after this for the next hearing. Nothing happened, my lord, after that. We got a notice, my lord, on 5th of November. I'm sorry, my lord, on my lord, 17th of December. Lord, you'll find at page 302.
It's 302.
Yes, my lord. That's the notice.
No, Mr. Sarkar, is there any order passed by the council terminating the conciliation proceeding?
Yes, I'll show, my lord. Kindly look at page 270.
Page,
That's, my lord, very next order.
page.
270, my lord. See the first line, my lord. Met on 20th December 2022, adjudicate the claims. First line. And then, my lord, it goes on. Summary of cases, my lord, are given. Now, lordship will see, my lord, page 273. Recording of the submissions made. Then, my lord, page 274. And then, my lord, after all the recording, under the above circumstances, council initiates conciliation process under so. That is, my lord, the first order. Then, my lord, next order, direct to, my lord. Then, second order starts, my lord, at page 274, middle. Now, see the order, my lord, very short order. Both parties present. The second order at the 274 middle. So, file written statement, written statement, the petitioner, a relationship, so and so. Your next page. Council has noticed, page 275. Operative part. Noted petitioner has submitted detailed spreadsheet incorporating bill so and so. Then, my order. Under the above circumstance, council declares conciliation process under so and so has failed, invokes arbitration. That's all. Well, with respect to statutory body, my lord, there's complete non-application of mind, my lord, forgetting the statutory obligation, my lord, pleadings, my lord, are filed, no, my lord, nothing, they, my lord, and they will file rejoinder, pleadings and, my lord, under circumstances, my lord, arguments, my lord, whatever is recorded, my lord, considerations comes to an end.
Yes.
The whole process, my lord, is certified. And I can show, my lord, actually, once the judgments of Supreme Court on this, my lord, what is the conciliation, what has to be done, and my lord, what is even, my lord, worse, my lord, with respect is, whatever was filed during conciliation is treated, my lord, as papers in the arbitration, which is, my lord, prohibited by law. The Supreme Court has said, my lord, you cannot treat those documents because, my lord, we don't know, my lord, it's a confidential process. Parties, my lord, exchange views, they make admissions, they can do a discussion.
No, conciliation is not that confidential. Mediation is. But Conciliation is not that. Otherwise, the council will not have any jurisdiction to arbitrate.
No. I'm saying, my lord, they must first conciliate, my lord. Lordship will examine whether, my lord, that was done or not done. That is my lord, short point, because, my lord, conciliation and arbitration can't go on together. Now, my lord, Lordship, what is more important, my lord, in the award, ultimate award, my lord, Lordship comes to page 96.
What has also been passed?
Award has been passed, my lord. We challenge that, my lord, in a writ petition, my lord. We are coming up against an appeal, my lord. Our petition was dismissed. This should require, my lord, Lordship's consideration on a point of law, my lord. Because Lordship will see, my lord, page 96 of the award. It will become very clear, my lord, what happened. My lord, what the council records in the course of the proceeding, opportunity was found consecutive. But, my lord, that can't happen.
No,
The judgment.
now the award has been passed. If you have the ground available to you, you can challenge that in the section 34.
No, my lord. This is nullity, my lord. Lordship wants, I can show you Lordship judgment, my lord, on this point. If, my lord, no under MSMED Act, my lord, if no conciliation is, my lord, taken up, and, my lord, council goes for arbitration, my lord, it becomes a nullity, my lord. It's not a question of, my lord, section 34, my lord. There is no award in the eye of law.
Therefore, the point which you are raising, you can raise under section 34.
No, my lord, with respect, my lord, Lordship, my lord, I said, 226 jurisdiction is constitutional matter, my lord, can't be taken away, but against statutory powers. Lordship will look at the judgment, my lord, once. Kindly see the judgment, my lord. Kindly see one judgment, I show you, Lordship, my lord. It is, my lord. My colleagues will give it to you, Lordship, my lord, in 2021.
What is the date of the order when the date when the conciliation terminated?
I'm sorry, my lord. 17 December 2022, my lord.
17 December
2022.
Yes.
No, my lord, Lordship, still, I'm sorry.
Date of award?
My lord, 7 September 2023.
You can raise this aspect. Did you file did you approach any authority before the award was passed that then you challenge that?
No, my lord. We have complained, my lord, before the council, then the conciliation had taken place. Council made an observation, enough opportunity has been given. That's what page 96. In the course of the proceeding, council said, my lord, during the arbitration, my lord, opportunity was considered given. That is not permissible in law. Their judgment will say so, my lord. Once arbitration starts, there can't be any more conciliation.
The order was passed on 17/12/2022.
Yes.
You knew that conciliation proceeding has terminated in view of, in the opinion of the council. Might have been wrong. Later, the arbitration proceeding started. There may be flaws in that proceeding. They might have council might have taken into account the pleadings which were placed in the course of conciliation for decision in the arbitration. You could have challenged that. You can challenge that, and you did not challenge that proceeding anywhere.
No, my lord, with respect, my lord, until my lord, we raised our objection, my lord, to the conciliation before the council.
Yes.
We pointed out to the council that has not taken place. Now, my lord, can't you see the finding of the council on that point, my lord? Kindly see the finding, my lord, on that council.
But the question is whether the court should interfere in such matters or not.
Because, my lord, with respect, my lord, because as I Supreme Court said, my lord, it's a nullity, my lord. Kindly look at the judgment once. 2021, my lord, 19 Supreme Court cases, 206. On an MSMED Act.
Yes.
I'll just show one paragraph, my lord, to your lordship. Same point, my lord, was urged where, my lord. Kindly take that, my lord.
Yes.
Kindly see paragraph 18, my lord. This is the same point was taken, my lord.
Paragraph 18.
18, my lord, at page 212. Here, my lord, award has been passed. Award, my lord, challenged, my lord, in a writ proceeding. The order dated, has the lordship got paragraph 18, my lord?
Yes,
The order date.
Just a minute, Mr. Shankar. Just a minute.
That will lordship has said that has been decided in India black and case that repetition is not veterinary, and the lordship clearly said, and the subsequent judgments are also there by giving the compilation judgment to judgment by law. And is concerned by law. This case, by law, what has happened section 18 procedure has not been happened. they have taken proceeded. That is the reason why this point was also raised for the amendment. They have raised any objection throughout the proceeding. The participant in the objection proceeding subsequently throughout the proceeding and allowed the hour to be passed. After the hour was exception certificate petition. And the kindly see Indian High Court case file. Whatever.
Lord, may I place paragraph 18?
Please wait. Just a minute. Wait.
Inside ceremony. 62. Just like one crystal place.
Continues. Thirdly, thus.
Paragraph 42. Basically, what is the digital page?
Continuation page 9 of the
Just a minute.
I'm sorry.
Digital page? Yeah.
Digital plus 81.
80. Yes. Bus.
Thus, that continues with narration. 34 and 19. Thereafter, that maintainability issue is also there. So if it is 227.
Yes, Mr. Sarkar, we are of the view that this judgment in Jharkhand Urja is distinguishable.
Paragraph 18, Lord?
Paragraph 18 we have seen.
Yes, Lord.
And we have to decide the matter based on the background in which the Jharkhand Urja was decided.
No, my Lord, I'm on the point of law, my Lord. I'm point of law, my Lord, is whether, my Lord, 34, I have to go to 34 or not, whether it lies or not. I'm on a pure question of law, my Lord. It's not a question of fact.
We have understood.
Well, that 34 point is taken in paragraph 18, Lord. You will see that. Paragraph 18, Lord, you will see this true by who have an applicant in section 34 at the same time in order is for recourse to arbitration and order so and so will not apply. We cannot reject the appeal only on the ground 35 below remedy 34. That's a question of law, my Lord.
Only
Whether, my Lord,
this is question of law, Mr. Sarkar. Question of law.
No, my Lord, where writ lies or not, my Lord. Lord should ask me a question whether writ lies or not. I'm only pointing that out, my Lord. A writ can lie.
Mr. Sarkar,
But of course, my Lord, facts will be different.
Mr. Sarkar, about a week ago, we were hearing a case again from this MSME, an order passed by the council. If we were inclined to entertain the writ petition, rather we are interfering in that case in the writ proceeding. So everything will depend on the facts and circumstances.
Yeah, of course, naturally. I don't see. No, my Lord, I'm only pointing out, my Lord, no opportunity was given here. But as your Lordship said, my Lord, I don't know whether, my Lord, we could have gone, my Lord, at that stage before, my Lord, the arbitration started or not, my Lord. Of course, I haven't examined that point. But, my Lord, fact remains, my Lord, the award came within a very short time. Well, within, my Lord, months. So, my Lord, and, my Lord, see, my Lord, no, my Lord, what I want to show, my Lord, the perception, kindly take page 96, my Lord. The perception of the council, my Lord, is, my Lord, with totally erroneous. Look at page 96. Council thought, my Lord, in the course of proceeding of arbitration, my Lord, conciliation can go on. That is page 96.
Whatever are we arguing, Mr. Sarkar, that is available for you to raise under section 34.
My Lord, my short point, my Lord, is there is no award in the eye of law, my Lord, as the Supreme Court said, if, my Lord, if there illegality, my Lord, has been committed by, my Lord, by the tribunal, it is not a question of jurisdictional matter in that sense. I'm not on the 34 as, my Lord, grounds will be there, may not be there, my Lord, I'm not concerned. But when the fact remains, my Lord, if the arbitral tribunal, my Lord, lack, my Lord, inherent jurisdiction, you know, not a question of, my Lord, territorial, any other jurisdiction, but inherent jurisdiction, my Lord, there is no, it's a nullity, my Lord. That's, my Lord, that, my Lord, appears to Supreme Court judgment. I'm only relying on that for that proposition, my Lord. That can be a nullity. Lordship would examine whether nullity in this case or not, but of course has to be examined.
We will hold that if you say we will distinguish, whether we can distinguish or not, we can't say, but we'll decide. We will decide.
Lordship, with respect, Lordship consider this point. That's all that I'm saying. Lord, it's not a
Mr. Sarkar, whatever you say, we have a duty to consider.
No. I know, Sir Lordship, Lord. I'm grateful to Lordship, Lord. I'm requesting, Lordship, Lord, kindly, Lord.
No, we'll surely consider every aspect. Heard and senior counsel appearing on behalf of the Krishna and senior counsel representing the other side. Leave this matter for judgment. First week of July. Yes, Mr.
I'm grateful, Lord. But I'm only asking, Lord, for a stay, Lord, of the execution until Lordship delivers the judgment.
Not now.
Should not become infractions, that's all, Lord.
About two separate judgment credit rely on the interjudgment text selection mechanical. It will give separate orders. Possibly.
Yes.
Item number
Grateful,
7.
Lordship.
Item 7.
Here, my lords, the appellant petitioned to register the role of vehicle, my lords. He has paid the motor vehicle tax in good time, my lords. By the annex of 2, my lords, it is payment has made through the online, my lords. Thereafter, my lords,
WA 10
he has paid the tax.
10. Yes.
Annex 2 is the bank statement. He has paid the tax for the period that is paid.
Yes.
Annex 2 is page 16. That is towards bottom, second minor, second one. He has paid the tax of 11,500 on 8th July 2023, minors. On the bottom, second item, minors. Thereafter, minors, this amount has been paid for the period July 2023 to September 2023. So next, my lords, next quarter comes from October to December, my lords, 2023. When he wanted to pay the next quarter, my lords, the system, computer system did not take it, my lords. Then he inquired, he came to know that that amount had not been adjusted, which has been paid in July 8. Then he approached the registry, that is RPO by the annex of 5. And the Joint Commission of Taxation by the annex of 6, he filed application. But that he wanted to pay the tax for next quarter, and that is computer system is wrong, and it is showing outstanding, and they levied the penalty 200%. So 11,500 double that is 23,000 levied penalty. Then, my lords, when I approached the register, that is the RTO.
What is the judgment of the
Honorable single judge disposed of the read application. The lordship will see that he has
granted you relief.
They granted me relief, but did not waive the penalty, my lords, for the period October to December, my lords. My money is them. As per the court order and interim order, I again deposited 11,500. The lordship may see the annex of 8, my lords. That is an interim order by this honorable court.
Now come to paragraph 6.
Paragraph 6 of my lords.
Of the single judge's order. If we are not correct, annex 12 is the order.
Then annex 10 is the order. That is the notification I filed that has been rejected, my lords. I filed a notification application to waive the penalty, but that has been rejected, my lords. That is the interim order in the annex 10, my lords. Annex 10
Yes.
is, that is paragraph 10, my lords. That is page 32, my lords. So accordingly, this court disposed of this request of the direction that the amount so deposited by the petitioner
through each one annexure 3 in the cyber treasury shall be transmitted to the account of the owner of the so and so towards payment of income tax and adjust accordingly. The process of such transmission shall be completed within a period of 15 days from the date of production of certified copy of this order before the Director of Treasury, OP number 5. The petitioner undertakes to produce the certified copy of the order within a period so and so. Next members, paragraph 11. It is further held that the penalty imposed for non-payment of income tax for the period so as July 2023 to September 2023 will be waived. But my lords, I could not pay because I paid the tax in time. It is the difficulty with the treasury, my lords, treasury and also transport department. Treasury has already filed the counter affidavit. They stated that the amount has been credited to the transport department. So the whatever adjustment that will be done by the RTA, my lords. So the question of appearing before the OP number 5 doesn't arise. Because already it is, treasury has already filed the reply. The transport department has not filed any counter, my lords. If they say that they have received it, then to which account that has gone? They have not stated so in their reply. They have not filed any reply. So my response solution is I paid the tax.
And what is there in paragraph 8?
Paragraph 8, my lords.
So we are required to deposit in E1 portal.
No, I deposited my tax in due time.
No, in due time, if you deposit the money in somewhere else.
No, not somewhere else.
Please come to paragraph 8.
My lords, see the counter affidavit.
Or not.
My lords, your lordship, see the counter affidavit filed by the treasury, my lords.
Please come to paragraph 8.
Yes, submission. That is, taking note of the solutions made by the counsel for the parties. These courts find that the petitioner deposits and tax in respect of personal banking for period of July 23 to September 23 through each land in the portal of cyber. My lords, this is a wrong fact, my lord. Because money has been deposited in online, my lords. So the penalty. Through online mailers. That amount has been deducted from my bank account. I have not deposited in cyber treasury. There is no such a tribunal.
What about paragraph 11?
Paragraph 11 means they have only honorable judge is only allowed to waive the penalty for one period. But next period, that honorable judge is allowed. So my response solution is I am not a defaulter. I paid the tax. It is admitted by the treasury in the counter affidavit. Now the transport department should give it credit, not the treasury, because treasury has already transmitted the amount to the transport department. You will also see the annex, that is counter affidavit filed by the Director of Treasury matters. That is counter affidavit.
Yes, so is for the estate. What is the dispute about?
I am appearing for the transport department. But with the admitted case of the petitioner, that petitioner has paid the tax through online, but that amount has been credited to the another account.
By whom?
But it is during the payment, online payment, it has been credited to a different portal.
By whom? All right. What is the reason why he should be penalized?
Now that period we have waived. Because there is no fault on the part of the petitioner. So that period we have waived that.
Then what is the problem?
The problem is that in payment of subsequent tax, subsequent period, he has also been not paid within the time. So there is.
He has not paid.
Yes.
Which period?
October 2023 to December 2023. But how could it be minus? Because this is not adjusted. So if they would have adjusted the first period, that is September or July to September, the system did not pay it. The problem is the computer system did not accept the payment because the first period has been shown the outstanding. So that is the fault is there, minus.
So there is no contumacious conduct on the part of the petitioner for non-payment of tax. He has paid, but that has been credited to other account.
Not other account, minus. Yes. Minus.
So that is why the honorable single judge has waived that period.
So his contention is for a particular period, there was a wrong account credit.
Yes.
Right. with respect to that, current single judge has waived the penalty,
Yes.
correct? But subsequently that is adjusted,
Yes.
that previous period is adjusted.
Right.
Subsequent period, he was not allowed to deposit.
And there is also some delay.
That is,
No, that is not, if he could not deposit that amount because the earlier period was showing not paid, so how could he deposit?
Yes, but that's right. So, but in the interim
so
order,
how can you impose penalty?
period had directed to pay the tax with a certain period. But that the petitioner has not carried.
I said, there is order.
So that is,
My lawyer said is very confused.
Can be imposed on you also.
Yes, my one is a 10 months matters. I deposited 11,500.
the petitioner approached by submitting the entire fact before the taxing officer, you will take a decision.
I have submitted my lawyer.
Not side by side.
But section 13 provides that we have to submit the entire fact before the taxing officer, and we will consider and pass an order. So for an imposition of penalty is concerned.
He came to this court,
Right.
he filed a writ petition, then he has filed his appeal. And now you are saying that he should go to your clerk for this
This is
clarification.
for subsequent period.
Subsequent period,
He could not deposit. Because the system was not ready to accept that.
Lordship may grant 7 days time, I'll take instruction.
All right. As please decide at your own
your
level.
system, your system is not so accommodative and restrain him to deposit unless the previous amount is adjusted and stated to be not outstanding.
Lordship may keep it on
The
reopening.
amount of penalty which you are imposing, the same amount you may have to pay to the petitioner. Take a decision. Depends, as requested on behalf of the
The number, opposite petty number
1 to 4 minors.
1 to 4. This matter on first week of July. For him to seek instructions. And file affidavit if so required. Item 8.
My lord, I would pray. I would pray, my lord.
Yes.
Yes, sir. You're right. This may be taken on Monday. Unfortunately, I got a wrong file. I have borrowed this one. Is filed by it online on Monday.
Requested on behalf of the petitioner list this matter. Item 9.
No, please not. Limited point involved in this matter is my lords, admission into the management quota, this nursing college beyond the cutoff date prescribed by the my lords council. The lordship judgment, I was just going through your lordship judgment, leaves me a room to address all the issues. My only my lords limited point to canvas for your lordship today. This year we have not made any admission because we received the NOC 2 days after the my lords. So therefore, I was only praying one observation from your lordship that the non-admission of any students may not foretell any adverse consequences on us for the next year. Only that protection. But they might think of issuing show cause rising to admit any students. So the rest of it is covered by your lordships. Only that limited judgment.
This is which one I don't know. You have to take permission for 23-24 months.
23-24 is over.
Over.
24-25.
This continue. It's not yet been over. Not yet been completed.
We can
24-25, the process has begun.
Yes.
the process for admission might not have begun because we have not held examination.
Yes, sir.
It seems.
The NOC has not been given yet to finalization of NOC not for given for admission matters.
NOC has not been given.
Yes, sir. And that is on process. That is on process.
24, 25.
Yes, sir.
But you have to end the process by May.
Yes, madam. Right. Yes, that, I mean, we have this, but consider, we may consider.
That should be considered as,
Nothing can be.
so like that.
This writ petition filed by a nursing institution,
No, nothing is.
nursing institution in relation to admission to the nursing courses for the academic year 2023-24 has become infructuous. Last date for admission having already expired long back. When senior counsel appearing on behalf of the petitioner has however submitted that for the present academic session, no admission could be given to any student because NOC was granted by the competent authority after the cutoff date for admission.
After the cutoff date for registration.
For registration for the academic session 2023. In such background, failure on the part of the institution to admit students for the academic session 2023-24 should not prejudice the petitioner's case for grant of NOC
For the ensuing year.
for the academic session 2024-25. The said aspect of the matter shall be looked into. Next, this writ application is dismissed as having become infructuous, but with an observation that the competent authority shall keep in mind the circumstance in which, while considering the petitioner's case for grant of NOC, shall keep in mind the circumstance in which the institution could not give admission to the students in the academic year 2023-2020.
Great.
Item number 11.
As Raghu will also, for a small menu, will also be glad to take 40. Here, from the police station to our area is maximum distance is 12 to 15 kilometers. And there is a maximum crime rates. So we made application before the authority for establishment of an outpost. That has been a lordship has not been paid, so filing application reported this will be given direction to disposal reposer. That will be disposal and inquiry is continued. In the inquiry page 45, it was stated yes, it is required to be established outpost in the Balrampur village also. It will also be on the entire inquiry report is page 45. And that is not the automated database also.
So we should decide whether where the outpost
Then we decided also. Only the report will be also.
will carry out.
What may we tell? Because only decided.
We should never issue such directions.
Because then also decided is in 12/9/2022 year also.
Maybe
And report submitted before the superintendent police. Only superintendent police has to be carried out, but this man carried out since 2022 year also.
the present writ petition in the nature of public interest litigation has been filed for creation of a new police outpost in Balrampur village under GP means Gram Panchayat.
This is Gram Panchayat units.
Under Balrampur Gram Panchayat of Valiapal Police Station.
Yeah, this is also Malapal police station. Gram Panchayat is Balrampur units.
Police outpost at Balrampur in the district of Balasore. Full stop. And counsel, the petitioner is relying on an information obtained under the Right to Information Act, comma, a letter dated 18/10/2023
Yes, my lord. The report I have to application, but the limited report is also
by the officer in charge of the police station to the superintendent of police Balasore, disclosing requirement of establishment of a police outpost at Balrampur. Stop. Next. We are of the definite opinion that this court exercising writ jurisdiction while entertaining a public interest litigation should not issue directions as sought for establishment of police stations / outposts. Police stations / outposts. These are purely within the domain of the executive government. So this writ application has no merit and is accordingly dismissed.
Item 12. Item number 12.
So anything can be filed here. The petitioner has filed present writ application in the nature of public interest litigation, seeking direction to the opposite parties to sanction financial support for construction of Lord Daksheshwar Temple as well as Ma Birajai Temple and its premises. Stop. The writ petition is, comma, in the court's opinion, the writ petition, comma, based on the pleadings on record, is totally misconceived and stands dismissed accordingly. Yes.
Item 13.
Please, Item number 13 is a TIL matter, wherein we are challenging Annexure 7 and Annexure 10. Before that, this is an organization. The petitioner before Lordship is an organization which works for road safety. The president of the organization is a member of the National Road Safety Council, which is statutory council. Now, kindly have Annexure 7, which is the impugned annexure, Annexure 7 and 10. Annexure 7 is at your Lordship's page 116.
Yes.
Now, the short point is, the state government here is taking a decision where physical DLs, driving licenses, and registration, when a two-wheeler or a four-wheeler, any vehicle is registered, you get a registration certificate. That registration certificate, as per the central motor vehicle rules, have to be given at a particular format and in plastic cards. Realizes now everything comes as a card. Now, under Annexure 7 and Annexure 10, kindly see the state government is not issuing those. Kindly have page Annexure 7, page 116. Kindly have the last paragraph only. I draw your worship attention to the last paragraph only. Now, therefore, the state government in exercise of the powers conferred by Section 211A of the Motor Vehicle Act and pursuant Sub-Rule 2 of Rule 171 of the Central Motor do hereby dispense with the issue of smart card and paper-based RCDL and other vehicle-related documents with effect from 1st January 2022. Now, this was in 12th November 2021. Now, kindly have Annexure 10 again. Annexure 10 at 122.
Annexure?
Annexure 10 is 122. Here, my lord, they have said that it is optional. My lord, have you been?
Yes.
But I invite the call mention again to the last paragraph. Now, therefore, the state government in continuation of CMP Transport Department notification and in pursuance of sub-rule law this, do hereby make it optional for public to apply for issuance of RC and DL in form of plastic cards payment towards cost of cards and postal charges. Now, this is in direct contravention to two rules, Rule 16 and Rule 48. Now, may also see Annexure 13, which is the central MORTH letter, kindly have 138. Has it, page 138? 13 and 15 were two notifications, circulars or letters or communications by the central ministry. Has it,
Yes.
138, kindly see, this is Minister of Road Transport and Highways, 18 July 2023. To all the principal secretaries and transport commissioners of all state and UTs. Again, kindly have the last paragraph. Therefore, para number 4, therefore, DL is required to be provided in the form of a laminated card without a chip or a smart card type.
No, when was this issued?
This was in 2023.
18 June.
18 July, I'm sorry. 18 July 2023. This is page 158 and 141 is 9th February 2024. The two letters, which I'm relying on. Annexure 13 and Annexure 15. Now, I have also written several letters and emails to the state government.
This is your representation?
No, my representation is all in Annexure 10, my lord.
No, you are referring to page 145. Which page you are referring to?
I'm referring to
141.
Yes, my lord. 141 is another communication by MORTH, my lord, which is dated 9th February 2024. Again at para 4, and it is also addressed to all principal secretaries, transport and transport commissioner of all states. Again, para number 4, my lord, the reiterate. Saying that it is therefore reiterated that the driving license is required to be provided in the form of laminated card type without a chip or smart card type. The provision for registration certificate to be provided in the form of laminated card without chip or smart card type is required to be continued to facilitate such applicants.
So that is not mandatory.
My humble submission is mandatory. My kindly have, my lord, if lordship has the central rules, my lord. By the way, my lord, I have also given it. My lord, language is facilitate. My lord, language is facilitate. My lord, facilitate the last one. Facilitate always.
And therefore, a decision has been taken. Then that shall be optional.
My humble submission is that is precisely what I am drawing a lordship's attention to decide whether it is optional, whether the state government has the power to decide whether it is optional, we can give the physical or not give the physical method. Now, kindly have
how the public interest is involved. how?
I've written letters, my lord. My lord, what?
Yes.
Yes, my lord. Two, three things what I have highlighted.
Who is going to suffer?
My lord. My lord, what is happening? What we have brought it to the notice of the department and what I'm bringing, how many bringing to your lordships.
You have filed this public interest litigation.
Yes, your lordship.
You must demonstrate.
I will. Madam.
The public at large.
Yes, sir.
They are going to be adversely affected because of that. So who tell us one person who has been adversely affected because of any policy decision which has been taken by the.
I completely got it. My lord, there are two things which we wanted to highlight to your lordships. Number one, my lord, it is currently it is all being provided through SMS, which is a PDF. That is what it is being provided now by the state government. Now, my lord, in our experience, which we are working on, that is what we have brought it to your lordship notice, and we are getting several letters saying that these PDFs are number one, my lord, are not accessible to everyone. Not everyone has a smartphone today.
Whether any person had to face any problem because of that.
No, that was not
Then you should not, we should not entertain this PIL on that ground alone.
no, my
There
lord,
must be some element of public interest.
well, the public interest
Because some illegal decision has been taken according to you by the government, therefore this court should entertain PIL. This is not the way. And we don't know the reason behind this filing of PIL. We know sometimes.
That is why I have stated, my lord.
Yes.
I am aware of that.
Manufacturers.
I'm completely aware of that, my lord, focus on me, my lord. That is exactly why para 3 have stated it categorically. Para 4, page 4, my lord. Let me kindly have a glance.
We are not satisfied. PIL we should not entertain. Come file a writ petition.
Well, I'm not agreed.
Then you are not agreed. Who is agreed?
Well, that is why I have filed a PIL.
Who is agreed?
Well, what we're saying is that there is a notification. It's the rule 18, rule 16 and rule 48 categorically states that there has to be a card type.
What is your locus standi?
Well, that is why I'm inviting a lordship to para 3, madam. That is why I'm inviting a lordship. No, madam, I'm saying I'm para 3, madam. Kindly bear with me for a moment, madam.
Yes.
Para 3, page 4.
These applications should be.
I'm showing the bona fide, madam. If your lordship is not satisfied, madam, I'll take. I'm just trying to impress on your lordship of bona fide.
We are on prejudice.
Well, let me state that I'm not prejudiced then. If on that ground I should dismiss it, then I've got no case. But I'm only saying that I'm only showing a bona fide. I'm a member, I'm an international road safety expert, I'm a member of National Road Safety Council.
So road safety is affected.
Yes, madam. That is precisely what we're coming to, madam. Madam, now, because it is not a physical chip and it is not, madam, kindly bear with me. It is not a card which the central government is saying. It is not a mere card like which you only show. It is a smart chip which any police can use it, madam, to see the details. Now, madam, the PDF itself. Number one, it is not accessible to everyone. A PDF, if you just send the PDF through your SMS, now that is number one. Now, number two, PDFs can all be, there is every chance of being fraud on the PDF.
And card cannot be.
Not a smart card. That is, madam, kindly see the rule 16, madam, kindly have page 5, madam, and annexure 5, page 72. Page 72, my lord. It's a notification of the MORTH dated 1st March 2019. My lord, has it moved?
Just
I've given the notification. I'm inviting your lordship attention to page 72.
Now come to page 138.
130,
138.
138. Yes, your lordship.
Come to paragraph 4.
Yes, your lordship. But I will remember. Therefore, it is required to be provided in the form of a laminated card without a chip
or smart card type without a chip. Chip is not required. Laminated card without a chip, but or a smart card type. That's correct, madam. That is precisely what is there in page 73.
Now QR code is given.
Yes, your lordship. Now, madam,
Instead of this chip,
yes, your lordship.
a QR code is
Exactly, madam. My page 73 is detailed. Madam, kindly have page 73, madam.
You want laminated card.
No, I'm not saying anyone, I'm saying physical copies, madam, cannot be PDF. Madam, kindly have page 72.
laminated card type has been substituted.
Your lordship, madam?
The laminated card type or smart card type driving license,
Yes, your lordship.
that has been substituted. That has been substituted.
Yes, madam. A physical copy is required. Madam, kindly have page 72. The entire,
That is
yes, sir. Madam, page 72.
the smart card type driving license that is put in place.
Yes, your lordship. That is what madam, page 73.
The only person who can have grievance against this
Madam.
is the people who manufacture.
Madam. Your lordship has,
Otherwise, no other person has any difficulty with the estate government.
madam, I can't possibly,
The person if wants laminated card, after downloading the PDF,
He can get that down.
laminate on payment of 100. That is what the state government has declared, that 100 rupees is to be. So there,
madam. Madam, kindly have page 73, madam.
These writ petitions are set up by people.
Madam, I can't possibly defend that, madam. I can't, madam. I can only state what is there in the brief, madam.
Because you have not been able to tell us the public interest.
Madam, kindly have
Not even a single person has any grievance except you.
that, if your lordship, madam, I have only brought it to the notice.
Yes,
Madam,
yes.
kindly have, annexed, madam, I have given, I have written letters, madam, to the state government. Madam, kindly have a glance
Keep on writing letters.
at page 125. Page 130, what I have highlighted, whatever issues that we brought it to the notice.
All right.
Page 130. And madam, 70, madam, kindly have a glance at 73, which is the statutory form. Madam, that's my case, madam. If your lordship dismissed. Madam, kindly, if I can only beseech your lordship. Yes, madam, just if your lordship can, I will beseech your lordship, if lordship can put this, madam.
Yes.
On my contentions, madam.
Yes.
Because it's a statutory form which I am referring to, madam. And
If you want, we can reproduce your entire writ petition in our order.
no, madam, I'm not saying that. I'm only saying that
That's the easiest thing for us to do. And you should not remind us.
I apologize.
We give liberty because you are young people, young members of the bar. But this is not the way.
I apologize, madam. I sincerely apologize. I was only trying to say. Yes, madam. Item 14.
Lordships. Your Lordships, this is regarding lease for sand, Your Lordships. This comes under the Odisha Mineral Mining rules, Your Lordships. May I just take Your Lordships to the rules, Your Lordships? The Odisha Mineral Mining Concession Rules 2016, Your Lordships.
Yes.
I want to draw Your Lordship's attention to you.
In view of the force measure,
Rule 8, Your
Rule 8.
There's a rule 8 deals with the period for which these leases are granted.
Yes.
I'll just read that.
What was your period?
Your Lordships, initially the advertisement, it was for 5 years.
From?
2019, till 2000, I mean, it's expiring on 21st, 2024. And during this period, we have 2 years of COVID period.
So that's the case I'm precisely trying to make out.
Just file your affidavit.
Not
6 weeks.
I just trying for an internet, not third party interest to be created. That's all I would say.
Yes, we can do
Third party interest
Lease is going to be expired.
on 21st. That's what I'm saying.
So I pray that your lordship may direct that any decision.
No, not third party interest. I'm only saying.
without the leave of the court, that we can say.
Will be subject matter of the.
All right, we will take up the matter on Monday.
No, my lord, so lord.
No, we will take up
Monday,
this
it's not possible to get the instruction within a short period, lordship.
Tuesday, just tell us whether you are going to start the process of.
Lord, on 21st itself, the lease is going to be expired. So thereafter, the decision will be taken for advertisement or something. It will
Therefore, if
it
you.
will take some time, not that within immediately it cannot be done. So your lordship may keep it to reopening date.
The opening day, first of the court observes that in the meanwhile, that no third party rights shall be created in the meanwhile in respect of the, what is that?
Purchase.
Kangarhuda sand soil.
Kathajodi riverbed RS. What is RS? Tangarhuda of area.
Yeah, it is.
Soirat is named as Kangarhuda sand soil.
Odia name. It is.
In respect of
It's there at annexure 1 because it is in Odia, your lordships.
just
Page 21, if your lordships will see, that's exact area has been given.
in respect of
Kathajodi,
the query lease in question.
Yes, that I will clarify it manually.
Kathajodi RS Tangarhuda of
S. Kathajodi R stroke S Tangarhuda of area acre 35
decimals.
000 decimals for a period of 5 years. No, sir. But
Oh, bless.
Period of 5 years. Item 15.
Question item number 15. Last time also, when I had given a copy of the order, wherein it was also the claim of the petitioner was rejected by the land acquisition officer. And my friend pointed out that because he had submitted a sanction recommendation, he cannot do it. Now the authority that is director has rejected his claim on the ground that the claimant has got 4 date of birth. He produced documents on verification, the found that it's a fake case. So I'll file a detailed affidavit saying that even though there was a direction by the Supreme Court to not take a decision and pay the benefits, it cannot be enforceable and it can be executed. So on that line, I will file an affidavit for lawsuits with judgments.
So what is your date of birth?
Well, Lordship, the inquiry has already conducted. And as per the metrics prepared by the collector, as on the year, the date application of Lordship, in the 2017, the age of the petitioner was 22. In the year 2017, the age of the petitioner was found by the collector. The age of the petitioner was 22. That is, he is eligible to get the rehabilitation assistance. Therefore, a quantum of compensation 8,26,000 has been made, and the letter issued by the collector to the higher
Qualification.
minor.
What is your qualification?
Lordship, I am the displaced person. That the
Ground.
we have got 5 date of birth. One is
He may be having 11. But if he is an illiterate person, if he doesn't know,
non-educated person. Because other persons are even land and
just a
Plus compensation was paid. And family members who are adult and married, they are entitled to this benefit. Members, 2 or 3 members also get it. Now manipulating the age, they claim so that all the members can get it. And there are 5 to 6 cases dictated by the authorities.
All right.
So that is the
All right, file your affidavit. As requested by Mr. Samanthal and AGA, this matter on second week of July. So as to enable him to file an affidavit. In dealing with affidavit stating the circumstance in which the petitioner's case has been rejected, despite this court's direction for payment of the amount of compensation.
There is a clause in the patent policy. Beyond 18 years.
Yes.
Measure, if there is a measure, it is treated to the separate family.
measures.
So independently, he gets another compensation.
And the 8 lakhs in addition to the land cost.
Item number 16.
May I tell you, Lordship, the rate application may be listed along with the contempt application.
That cannot be, that has been disposed of. So you want us to rehear? You want us to modify that order?
The document filed by the petitioner along with the rate application, the original document has been filed.
Retribution लगवा लिया लो, बस contempt. Yes.
Vote to please join worship.
Item 16.
Yes, my lord. My lord, the order dated 22/2023 has not been complied, my lord. Last occasion, your lordship director, Lord Lord Council.
Please to grant the time on 6/5/2024. The Tahsildar, I written a letter, but he has not responded to my letter. So
The petitioner alleges that this court's order dated what is the date? 22/2023 passed in WPC number 37072 of 2022 has not been complied with. First off, learned AGA appearing on behalf of the contender has submitted that despite communication made to him, he has not corresponded. First off, this case on Monday, first 10 cases. First off, on the same date, the contender has required to join the court proceedings online for this court to initiate contempt proceeding against him for deliberate disobedience of the aforesaid order of this court by framing charge.
because there is election on 20th. Possibly put it on the reopening the if compliance otherwise you may be punished.
All right, reopening this one.
Reopening like that.
Item 17.
Item 17, I am appearing through VCO, let's say.
17th, he has been noticed and called upon to appear before the immediate chief on today at 4 p.m. and decision shall be taken. He has been noticed. This is the notice to the petitioner. So also we take it up on Tuesday so that decision can be communicated.
Yes, you appear before the
Yes, let's say.
IGA appearing on behalf of the contender has submitted that personal hearing has been fixed today when the petitioner is required to be present before the engineer-in-chief to Rural Works, Orissa, Bhubaneswar. So he has submitted that a decision is likely to be taken by Monday. Stop this matter on Tuesday.
Published.
Item 18.
18 both have been complied with. I have given a copy to my friend.
Complied with. Complied with. Item 19.
So 19, if lordships, I received a letter from the authority that the order shall be complied by today. So lordship may take it up on Tuesday so that I can implement the order to
Tuesday. As requested on behalf of Grand AGA, let's this matter on Tuesday. Item 20.
And on last occasion, when the State Council took time to comply with the orders dated 4/9/2023.
Yes, order has been complied and the detailed order has been passed by the authority. I can give it, copy to my lawyer friend so that he can do a detailed. I've got it, not the order, compliance order.
It is stated, we are disposing it off. We'll give you liberty if you. It is stated by AGA that the order violation of which has been alleged, order of this court violation of which has been alleged in the present contempt application has been complied with and a reasoned order has been passed.
Well, what did he do? Your date of order is your 4/12/2023.
On 4/12/2023. Stop. He undertakes that he shall hand over a copy of the said order to learned counsel for the petitioner in course of the day. Stop. In such way of the matter, the contempt proceeding is dropped with the liberty to the petitioner to question the correctness of the said order before appropriate forum in accordance with law, comma, if he feels aggrieved. To stop.
Obliged.
Orders item 22. How much delay?
339.
Issue notice. Item 23.
Well, there is also delay. This is regarding the job contract matter pending before notice and limitation.
On it, condonation or delay, what is the delay?
351 days.
51.
321. 321.
We are issuing notice in the window.
No.
Issue notice on the point of limitation.
Item 24. In item 24, there is a delay of 257 days. The lordships may condone the delay and dismiss the writ of appeal because the case has already been covered. A batch of petitions were filed.
I have the instruction to appear for the respondent. I am providing the copy of the judgment in which this particular judgment has also been satisfied.
Or senior counsel appearing on behalf of the applicant. And
common judgment was passed.
I am and counsel for the respondent. There is delay of 257 days. 57 days in filing the present appeal. Considering the governments made in this application, the delay stands condoned. Year number 5 is allowed. Stop. Next. WA number 5. And senior counsel appearing on behalf of the
Board of Secondary Education.
sorry, the senior counsel appearing on behalf of the appellant / Board of Secondary Education Orissa has very fairly submitted that this matter is squarely covered by a coordinated bench decision of this court in case of Board of Secondary Education Orissa Decision of this court dated 12/10/2023, passed in WA 1498 of 2022. Bracketed Board of Secondary Education, Odisha and another versus Madhusudan Nayak over Samla Pandu Rangarao and batch. Full stop. In such view of the matter, the appeal is dismissed.
25. Although notice has not been issued, but my learned senior is appealing for the response.
Well, I'm approving the instruction. I know, the response.
Yes, what is the delay?
2.5 years, my lord. 2 years, 3 months.
Yes.
The delay is no 475 days. How much? 475 days.
787 days.
787.
In the 9/6/21 judgment, they filed appeal at 4/9/23.
Excluding that period. COVID period.
Up to 31/5/22.
Still it is dead.
Really?
And I'm that just time young resumelers, the tenure of I have read the limitation petition. The tenure of the interpretation is where the government department file moved from this office to that office, from that office to that office. Two judgments, governments are the only Supreme Court and hand over to your lordship.
What is the decision?
Pardon?
What is the decision? What is that?
Judgment, my lord. A driver worked for 20 years. Against a regular post,
Dismissing it.
20 years he worked. Then court directed regular his service within 3 months.
All right.
Now it's 25 years.
The state of Odisha has challenged the present and has put to challenge an order dated 9/6/2021 passed in WPC number 13784 of 2021. One appeal in 2 cases.
No. One appeal was the original judgment dated 4/6/21. Because they didn't implement that order of the Legal Code, petitioner filed the respondent filed another petition to direct them to comply with that order.
9/6/2021 passed in WPC number 1387.
What's that really appeal?
13784 of 2021.
Yes, this is the appeal. It's very good.
Stop. The writ petition, the writ appeal was filed on 4/9/2023 and is apparently barred by limitation. So stop. There is delay of
475 days.
475 days,
Excluding the
excluding the COVID period, in the light of Supreme Court's decision in the case.
Let us not say that. 787 days because 9/6/2021.
This is what he is on. Tell me. Even if the period, even if the COVID period is excluded or stopped, the, where is your IA? IA is 6115.
No, IA is 6115 at, no, IA is 6116 at flag B. Number 96, flag B.
There is detailed here.
From the governments made in the application seeking condonation or delay, it is manifest that the impugn order was communicated to the principal chief conservator of forest and H small O double F Orissa on 14/7/2021. Except of the fact that the file remained moving from one department to another on for taking a decision as to whether the order was to be implemented or an appeal was required to be filed. There is no other explanation available on the court. Satisfactory explanation available on the court. Stop. In such view of the matter, we are not inclined to condone the delay. The IA number so and so is accordingly dismissed. Consequently, WA number so and so dismissed. WA accordingly and dismissed as time bar.
Item number 26.
This repeats filing challenging the improved judgment dated 19/2003, passed in WPC number 8551 of 2012, my lord. In this case, the ex parte judgment has been passed by the Honorable Single Judge, my lord. The ex parte judgment is when passed in the single judge. Which item number? This chair came to the knowledge.
Just a minute, just a minute.
Item 26.
No, please. This writ appeal has been filed challenging the input judgment dated 19/1/2023 passed by the Honorable Single Judge.
No, but he has been listed for order. Why?
My lord, delay to 240.
200?
Days, my lord.
So item 26, yeah. Item 26.
You're not assigned any reason.
No, this may go on limitation, my lord.
And you are challenging this order, 19/1/2023.
My lord, I challenge this order in the present writ appeal, my lord. I challenge this order in the present writ appeal. It came to my knowledge when the Tahsildar issued notice about the limitation. At that time, it came to my knowledge because this was the ex parte order. So limitation is 245 about 245 days. So limitation notice may go.
So you are not a party.
I was party, my lord.
Then?
From the order, it came to my knowledge that notice was issued, but notice was not served to the client. The valuable property right of the petitioner is taken over.
The notice was not served.
And
You filed review application.
my lord,
You could have filed review.
I could have filed if your lordship will permit me because
We'll permit you. By selling the
my lord, otherwise I may be given an opportunity to edit my grievance in the writ appeal, my lord.
no review, we cannot.
But
By selling the by selling an order dated 19/1/2023 passed in WPC number 8559 of 2012, passed by a learned single judge of this court, learned counsel appearing on behalf of the petitioner appellant has submitted that appellant has submitted that the appellant was implemented as opposite party number
opposite party number 1, my lord.
opposite party number 1. But no notice was served upon him. And in his absence, the impugned order has been passed by the learned single judge. Stop. Pressing his application for condonation of delay, he submits that after the order was passed, that after passing of the order dated 19/1/2023, when what is this explanation? The petitioner learned about the said order from the office of from Tahsil office, Basta on 15/9/2023, whereafter, upon advice of the learned advocate, he filed the present appeal. To stop it. Next. In our opinion, if the petitioner did not have the opportunity to appear before the learned single judge in the proceeding, and was agreed by and is agreed by the decision of learned single judge. Decision in the writ petition of the learned single judge, he would have been better advised to seek the review or recall of the said order. In the facts and circumstances of the case, we dispose of the writ appeal with an observation with a liberty to the petitioner appellant to seek review of the order. Stop. IA number so and so stands disposed of. Useless.
टाइम में चाहिए टाइम में जस्ट वैकेशन वाला time kindly.
We cannot fix any time. You will have to file review. Or you do them.
Next one is also same 2419.
Both the marks.
Item 27.
Your file. So review we call that.
Item 27.
May I please your lordship? May I please you? But there is a delay of 89 days. The petitioner is a government employee and the state is the opposite party. We were not aware of the judgment. The cases were transferred from the state administrative tribunal after it was closed for 2 years. The cases were transferred to High Court and the matter was listed after many years once and then subsequently in the supplementary list.
So is it the of such order?
Madam?
You should seek review of the order.
So I have come on the record. Appeal against the judgment passed by this.
Appeal against the judgment passed by learned.
This order is
Did not appear, then how can you assail the order?
No, I appeared. Related to me. I was in the district of Raigada. The case came up and he argued it. And subsequently the order was passed. But it was not communicated to me. I was in the remote district of Raigada. So that is why the delay was taken place inadvertently. And even I could not find my so-called reply. There is a mandate from the order of the Honorable High Court, which is also under challenge.
The what is the delay?
Delay is 89 days, no much.
89 days delay we can condone. Condone, I. All right.
Okay. Item 28. But I thought the main matter may be taken up Monday.
No, we'll come for admission.
Item 28.
The rehabilitation matter of 131 8 days delay.
What? Explained before last week. What only data. Our father was died since 2013. The respondent before last week since 2013 had not got any job, even though for mother and neither really see and nor her about the physical result person. Only person.
No, we are on the question of condonation of delay only.
Yes, sir. 131 days.
And 31 days can be condoned.
That's it. The delay is condoned, the respondent will suffer irreparable loss. Since 2013.
And if delay is not condoned, then the state will suffer.
As to delay condemning, what has been a point, so it is sorry.
Point which is
Point.
you have a point.
Yes, some point is there, only very limited point. That in fact, at the time of death, wife and daughter both are there. Death was occurred in 2006. At that point of time, wife and daughter, as per the rule, either wife can apply or daughter. Daughter did not apply because she was minor. Rule says, in absence of any family member, if one minor was there, he can apply after attaining the age of 18 years. This is the case. Our case is that since wife was there, she could have applied in 2000, the period of limitation 1 year on the rehabilitation assistance scheme. As she has applied in 2013, so on that ground of limitation that was rejected.
Not a ground of limitation in university. In 2013, the respondent's application was accepted and verified because due to at the time of death of her father, the mother of the respondent petitioner was a disabled person. Therefore, she filed an application affidavit before the authorities.
Who was disabled?
The mother of the petitioner was the wife of the deceased employee.
Was disabled?
Disabled person. And the medical certificate also filed and affidavit also filed. Thereafter, the collector also condoned the delay and accepted the application, but not given appointment since 2017. In the year 2017, the application of the petition was rejected on the ground that where the south was added. South is added. Only ground, not delay ground, you must say. That's why you must say this underwood has passed the rejection order and directed to get appointment, give the appointment to the petitioner.
Mr. Kuntia, in many cases in this court, we have already passed that if mother is found unsuitable to take up or undertake any government job.
Perhaps in one of the cases, you will have, perhaps in one of the cases, you will also have passed a judgment, but I have not gone through that judgment. I was searching that judgment from my, on last decision, the matter was placed before my lords.
When it is the medical board.
Yes, ma'am, that
medical board, if has given a certificate.
Yes, ma'am.
As per rules.
Yes, ma'am. That rules provide one of the judgment, my lord has passed that judgment. In one case that I have also requested one of my friends to give me that judgment because that's not a repeat. Yes, ma'am. I will also call this, I will go through that judgment. If this is not a case, he was referred to the medical board. He has submitted a medical certificate that he has. And the
medical board is required to be
medical, yes, my lord.
Comprised of surgeon and another physician.
There is a board, when district, when the state, there are two boards are there. In the district, there is the district board and the state board. State board is the appellate court, the district board is the competent authority to grant the certificate. There is no dispute about it.
And minor is also not disputed because
minor is not
provides that.
Yes, minor can apply. Minor can apply if there is no other member in the family. That is the rule. And there is a limitation after attaining the age of 18 years. There are limitation 3 years.
Yes. So that decision.
Delay.
Again, matter tomorrow, Monday. Well, and meanwhile, we may have that decision also. And while condoning the delay, we can dispose of the appeal.
Yes, ma'am.
With your consent. Well, not the order will not be with your consent. Hearing of the appeal will be with your consent.
Because pending also will prejudice vote. If you pending also. Rehabilitation.
Very poor petitioner referral, only data.
We will see.
Item 29.
At 29, 237 days delay.
Mr. Kuntia, you also take us to those evidence. It is not medical board, but it is medical certificate.
Yes, but
And that will.
I forgot my last judgment that I have requested
that there is no difficulty. On facts also we can. But that rules, somewhere I have gone through that medical board has to.
in that judgment, I have to know that you will also have gone through that medical board.
Then preference, order of preference is mother, then order of then daughter.
Well, in order of preference, there is no dispute to be there. Those who are coming within the family members, they will get. Here, this is not the case of 2B.
As far as my memory goes, if mother is held to be incapacitated by a duly constituted medical board, then the next order of preference person, that is son, in absence of son, then daughter.
Yes, ma'am. That is
So
also.
maybe married or unmarried, it is immaterial because we have struck down that married part. So daughter can also apply.
In the case of Ajit Bari case, that 2B has been defined of how even if mother is present, second son daughter can apply. But within time, here mother is there, he has applied after 6 years. That is the case here.
Let us.
Well, let's not take it to Monday. You'll also think Monday.
Item 29.
At 29, 237 days delay, this is a case, my disengagement of a contract teacher. We have issued notice and after issuing notice, following the formalities, we have disengaged, that has been passed by. So the limitation will also may issue notice limit.
Issue notice limitation.
For admission, item 30.
JLP, while order number 58 on 3rd of May, the Lordship listed out the issues that can be taken up.
Which order?
Order number 58 dated 3/5/2024.
Yes. Yes.
We have filed an affidavit yesterday. I have just handed up the affidavit because it's e-file, so we might not have come on record. The Supreme Court verdict. With regard to the issue of overcrowding, out of floods 87 jails.
Yes.
Out of floods 87 jails, as on today, my lords, 20 jails are found to be overcrowded.
20 jails overcrowded.
Overcrowded, and my lords, the percentage of overcrowding is from 1% to 97%. So we have given all the details, my lords, of these 20 jails.
Yes.
If my lords takes my affidavit, page 7 of my affidavit is a tabulated chart.
Yes.
Please, my lords. So, sub-jail Kamakhya Nagar, the scheduled capacity is 69, but the current population is 136. Whereas I also must bring it to my lord's attention that this is typically, whereas there are only 3 jails where we have seen a trend of overcrowding. The 2 jails are, my lords, the district jail at Jajpur and the district jail at Bhadra,
which my lords had taken note of in the last hearings, and my lords also Bhubaneswar. Apart from these three jails, the trend of overcrowding is not seen in all of the other jails on a regular, consistent basis. But in Kamakhya Nagar, there has been a sudden spurt in the recent days, my lords. And in fact, to reduce this population, we have also sought the permission of the trial courts, and that those figures we have also given at page 5, my lords. Para H.
Yes.
Para H, my lords. At sub-jail Kamakhya Nagar, if my lords sees, 136 is the current population as opposed to 69, which is the scheduled capacity. We have already sought permission to transfer 37 prisoners, 37 inmates to nearby jails. And if the permission is granted, then the percentage of overcrowding would come.
Where will you take them? From Kamakhya Nagar, which is the closest jail?
From Kamakhya Nagar. We will be taking them to the jails nearby, my lords. I'm unable to say which jail exactly, my lords. But with regard to the other jails, my lords, Jajpur and Bhadrak, we are, my lords, taking them for Jajpur. For Bhadrak, my lords, we will take them to Soro. And from
No, that is there.
Please,
but what about this?
Please, for Kamakhya Nagar, my lords,
This is in which district? Kamakhya Nagar?
Angul. Angul.
How far is Angul? Any idea?
3.5 hours from Kattaka.
Yes.
No.
Kamakhya Nagar. Yes. Well, it's about 55 kilometers.
And what is there? Angul? What is the position of Angul?
There's Angul.
Athamalik will be nearer.
These minutes?
Athamalik.
would be.
Kamakhya Nagar to Athamalik.
Athamalik would be about 136 kilometers. 136.
But it has enhanced capacity now.
It has enhanced capacity.
That may be the nearest from Kamakhya Nagar. No other.
Angul's circle jail Angul has a capacity of 418, against which as of today there are 362 inmates.
Yes, what can be done, Mr. Member Secretary?
Namaskar. My lord, Lordship has identified the last
taken by the Home Department and the Prisons Department. So they would be in a position to figure out as to where to shift, taking into account the security concerns and the present capacity. Like imbue is always more or less up there. There's not a case where there's a huge gap. So I think that instruction he will have to pass on to the state council. The immediate steps regarding Kamakhinagar, they can take. So that is, Kamakhinagar is something which they will have to come back to your lordship. And regarding Bhubaneswar, if your lordship sees para 6 of the previous order, there was a specific direction vis-a-vis Bhubaneswar. That I think they'll have to tell your lordships. It's the state council regarding that. And the member secretary is to reply vis-a-vis your lordship's directions in paragraph 10. Paragraph 6 vis-a-vis Bhubaneswar, which remains a problem.
No, even otherwise, he is a member secretary legal service authority, he can advise the court on various grounds, on various aspects.
Even the bail bond relating issue, non-furnishing of bail bonds, there the numbers were 444 as on the first, as on 5/4/2024. That has come down substantially because of the intervention of the court. But in the meanwhile, around 329 new additions have come.
That will happen.
Yes, so that also is something which they have to look into. But that, I think that the 1 month window has not yet kicked in. The Supreme Court direction is that within 1 month you have to show more to take it.
Yes.
Yes, my lord. As per your lordship directions, we have collected the recommendation and opinion and suggestion of the UTRC committee and compiled it and filed before your lordship for convenience at flag 148, my lord. The UTRC committee has suggested that there are a number of suggestions we have compiled and filed before your lordship. And my lord, I may kindly be permitted to say that in
146, 148 is not there. Flag 148 is not there.
Right. The Honorable Supreme Court in WPC number 406 of 2013 in reference to inhuman conditions in 1382 prisons. In the order dated 30th of January 2024, has been pleased to direct that to constitute a committee in each district consisting of the principal district judge is the chairman and collector, concerned collector and superintendent of police and superintendent of jails and secretary DLSA to constitute a committee to oversee the infrastructure and overcrowding of jails, my lord. In Odisha, my lord, in all the districts, the committee has been constituted and they have submitted their report to the government in home department, my lord. The government in home department is monitoring the committee, the progress of the committee. This is one of the suggestions in the UTRC opinion, my lord. And there are a number of suggestions, my lord. I may be permitted to read, my lord.
What are the suggestions?
We have compiled it. 33 suggestions have been. We have compiled it and filed before your lordship. The state. May I read now?
Please, no, the suggestions which are important.
Yes, ma'am. The number of suggestions we have compiled, the state government should be impressed upon to provide necessary infrastructural facility to accommodate the prisons in accordance with the Rule 7B of the Odisha Prison Rules 2020, which includes construction of new prisons at places where courts are functioning, but where there is no prisons, upgradation of overpopulation prisons. And the next suggestion is where a particular jail is overcrowded, steps in accordance with the Odisha Prison Rules, jail manual should be taken by the authorities of that particular jail. Next one is that the magistrate dealing with the accused persons at the first instance should be encouraged to grant bail to the accused persons involved in bailable offences through execution of PR bonds instead of forcing them to arrange suitable surety. The next one is, my lord, the magistrate should meticulously follow the provisions envisaged in first proviso to Section 437(1) of the CRPC. The next one is the trial courts must strictly adhere to the provisions of Section 437(6) of the CRPC in appropriate cases. And the next one is steps should be taken in to motivate the session judges to invoke their powers conferred by section 440 subclass 2 of the CRPC. The Secretary DLSS should emphasize the early submission of petition under section 440 subclass 2 and 437 subclass 6 of the CRPC through the counsel engaged in LATCO as well as other panel advocates in appropriate cases. The Secretary DLSS should interact with the family members of the prisons who are, as per the assessment, are entitled for being released from jail on regular basis to take suitable steps in coordination with the DLSA for early release of the prisoners from the jail.
Mr. Well, suggestions, please be careful.
Yes, ma'am.
You are writing this letter to the Registrar Judicial,
yes,
and you are making a suggestion that steps should be taken to motivate session judges to invoke their powers conferred by section 440. So this suggestion is to the Chief Justice.
No, my lord, this is the suggestion given by the OTRC committee, my lord. We have just compiled it and filed for your lordship.
Please be careful. This is not the way. They exercise their judicial powers.
Yes,
and if the Chief Justice has to motivate, that shall be on a different platform.
Yes, ma'am.
How could you think of making such suggestion? Magistrates should be motivated. Who shall motivate?
My lord, this is
Who shall motivate? Tell us.
Aye.
You are a judicial officer.
Yes, ma'am.
Who shall motivate them?
My lord, these are the suggestions of the
honorable administrative judges and the Chief Justice. This is your suggestion.
My lord, I may kindly pardon, my lord.
Please be careful.
My lord.
Yes, so what do you expect? How much time will it take for you to obtain orders from the court?
My lords, we have already sought the permission, so we expect in a week, 10 days time, the courts will take this up, because in Bhubaneswar, my lords, because the overpopulation against 991, there are 1345 inmates. So we have sought permission for 242 inmates. So if we are able to get, because most of, in all of the cases that.
Can we convert the Orissa guest house into jail? Bhubaneswar guest house?
No, it's in Bhubaneswar.
That can solve the problem a lot.
No, it's from Bhubaneswar jail. We are shifting to two jails. One is the district jail Puri and the sub jail Banapur. These are not very far from Bhubaneswar.
Very good. Banapur is about more than 90 kilometers.
No, it's no. Banapur would be
60, more than 60.
It will be around 9.
Banapur.
And Puri would be 70 kilometers.
It is 60 to 65, but Banapur will be 8.
Around 98.
Solve it by next day.
Bangalore is 98 kilometers.
Otherwise, we will direct the guest house to be converted into a jail. This is not the way. An affidavit has been filed on behalf of opposite parties number 1 and 3, which discloses a very gloomy picture on concerning overcrowding in jails. First off, annexure AU bracketed 3 of the said affidavit is in tabular form showing percentage of overcrowding in various jails in the state of Odisha. In some of the jails in the state of Odisha, which is as under. Stop. It has been stated in the affidavit that steps have been taken by the state authorities for shifting of prisoners from the prisons which are overcrowded to such prisons where which are not overcrowded and the number of inmates is less than the capacity of such jails. First off, applications have been filed. Petitions are said to have been filed before concerned courts seeking permission for shifting of the prisoners lodged in overcrowded jails. Stop. We shall pass appropriate orders in this regard on the next date when the matter shall be next date, that is 26 June, if in the meanwhile there is no satisfactory progress, the direction of tackling the situation of overcrowding in jails, in some of the jails. So stop. The member secretary has brought to our notice a letter number 1864 dated 16/5/2024 addressed to the Registrar Judicial, High Court of Orissa, which is this is UTRC report.
Yes, my lord. These are the suggestions and opinion given by the respective UTSC committee, my lord. We have compiled it and placed it before the lordship. As per your lordship direction in the last on the order dated 3/5.
Who is the chairman? Who happens to be the chairman of UTRC?
The learned district judges, sir.
We should initiate contempt proceeding against them. They are asking the district judges to be motivated. Containing which, according to him, is compilation of the suggestions received from various UTRCs. We feel disturbed in relation to suggestions which have been made by the UTRCs. For the present, we are not recording our displeasure in the present order. So, the member secretary has joined the online proceedings, has joined the proceeding online. He will not be required to join any proceeding in future. Yes. Right. You see. We direct the secretaries of the respective district legal services authority is of the state to ensure effective steps taken for release of such prisoner under trial prisoners on bail who have not been released, who are not being released because of the failure on their part to furnish sureties. Yes. We will see what happens.
Maybe pardon, my lord. My lord, your lordship will be sitting after lunch, my lord, because usually.
If you say, if you tell us, we will sit. If you require